Carrie, are you in charge of the recording? Or Zaina?
Great, thank you. This meeting is called to order. Good morning and welcome to the April 12th meeting of the Douglas County Criminal Justice Coordinating Council. My name is Pam Weegan and I'm the chair of the CJCC. I want to pass along a bit of information regarding how we'll conduct our meeting on Zoom today. We ask that all members please turn on video if you have it. We ask that all members and presenters use good conference etiquette, call etiquette, and mute their line when not speaking. We ask that you please identify yourself each time you speak. And if you have public comment to make during the public comment section of the agenda, please use the raise your hand function on Zoom. The recording of the CJCC meetings are available on the CJCC website after each meeting. Today, we want to welcome our newest CJCC member, Taylor Jones. She's Commissioner Reed's appointee. I'll let Taylor introduce herself.
Good morning, everyone. My name is Taylor Jones. I use the she series pronouns, so she, her, hers. I am currently one of the prevention coordinators over at the Sexual Assault Prevention Education Center with the University of Kansas. Previously, I had a lot of work and involvement with the Willow Domestic Violence Center as their Director of Community Services. I also have facilitated battering intervention groups for Satori Counseling Services. So any groups for those who have charges for domestic violence, domestic battery, destruction of property sometimes as well. So that is a bit of the experience that I'm coming to this group with, and I'm so excited to be here. Thanks for having me.
We're glad to have you. Our first agenda item today is a discussion about juvenile justice reform with Pro Tem Judge Paul Clipper and myself. I don't know if Lee Hasman from my staff made it on the call, but we've put together some statistics.
She has. We'll move her over. I didn't know we were
Okay.
moving her over.
Yeah, I just wanted to make sure she was available in case people had questions that she can answer. Lee Hasman is the Assistant Director of Juvenile Programs for Criminal Justice Services and oversees the programs that we're going to be talking about this morning. I don't know, Judge, if you had any comments you wanted to start with before we get going, or.
This is Judge Klepper. Not particularly. I mean, obviously, I'm always limited to some degree in the things that I can talk about. I think this is very helpful data. Obviously, I saw it when Pam first showed it to me and put it together, so it is very enlightening. There's a lot of good stuff in there. I hope people think it's mostly good news. But that being said, I'm here to answer whatever questions I reasonably can.
Great. Matt, do you want to start the slides? First up, I want to thank and acknowledge Rachel Schneider and my staff who put together the slides and the data for us today. First of all, the juvenile justice reform work started in 2011 here in Douglas County, because when we agreed to participate in the Annie Casey Foundation's Juvenile Alternatives Initiative. Senate Bill 367, which is the state's comprehensive juvenile justice reform bill, was adopted in 2016 with a timeline to build and create the needed infrastructure and programs that were outlined in the bill. The reform was fully enacted in July of 2019. Senate Bill 367 was basically enacted to promote public safety while holding juvenile offenders accountable, control taxpayer costs, and improve outcomes for youth, families, and communities. By reducing juvenile incarceration and out-of-home placements, by improving outcomes for youth supervised in the community, by increasing the use of community-based programs and alternatives to detention, and shifting state resources to evidence-based programming, and standardizing diversion processes and supervision standards. Let's go ahead and go to slide 2. When we reviewed all the juvenile data for criminal justice services, we decided it would be easiest if we divide the services into groups today and focus on services for pre-adjudicated youth. And this kind of chart really doesn't really depict, youth can receive a diversion at any point in the process prior to adjudication. And that was really hard for me to depict because I'm no PowerPoint expert. I wanted to make sure you were clear about that. We can move on to slide 3. Juvenile intake and assessment serves both child needed care and juvenile offenders who are brought into intake by law enforcement, or youth can be issued an agreement to appear, which is a ticket in the field where they then make an appointment to come in and do their juvenile intake. Intake staff basically help determine what services or placements youth that brought into intake need. That can be what they call police protective custody placements, that they may go to a shelter, a foster home, relative placement, or detention. They may need mental health screening and go back to LMH for that, or they may need to be booked and processed through the detention center. Booking and processing of alleged juvenile offenders has been done by Criminal Justice Services since 2006 for the Sheriff's Office. We can move to the next slide, please. As you can see, what we tried to do is go back to before the time when Senate Bill 367 was enacted, just so you have an idea of the numbers. But if you look at the bottom chart, you can see that the number of juvenile offenders and children in need care has decreased pretty steadily. Now, obviously in 2020 and 2021, there's obviously the impact of COVID. One big difference in Senate Bill 367 that didn't happen until 2019 was the removal of children needed care from detention. And so those numbers of child needed care cases starting in July 1 of 2019 couldn't be placed in detention. And so sometimes the outcome might be a little different for those youth. The other thing I want to point out is that Criminal Justice Services didn't start doing juvenile intake and assessment until 2018. So some of the prior data is purely numbers. We don't have demographics for those youth. You can move to the next slide, please. As you can see from the graph, the basic age groups of youth that we see, and we really do serve youth from birth to 18. And generally the youth under the age of 10 are always going to be children in need of care. A youth cannot be considered an alleged offender until they're age 10, and that's highly unlikely. It doesn't happen that often, but you'll see the majority of the youth we see are in the teen years, 15, 16, 17. You can move to the next slide, please. This is just the gender, race, and ethnicity breakdown of youth that are brought into juvenile intake. I don't know that it tells you that much because that doesn't really tell you the outcome of those cases. But it gives you an idea of the numbers of youth that we see in a given year in the intake center. Move into the next slide, please. The next program is called the Immediate Intervention Program, which in the juvenile world means diversion. The district attorney's office is the one that makes all the decisions about who receives a diversion or who receives an IIP. And the requirements of IIP are outlined in statute. If you move to the next slide, you'll see the supervision of youth. So there are 3 levels, level 1, 2, and 3, both pre and post file. And it outlines for us as the supervising agency what we're allowed to do, and it gives specific timeframes. So we're not over supervising low-level youth or youth who need to be diverted. So I think the whole program, nothing can exceed more than a year in time on an IIP. Let me think, let's see. We started the IIP program in October of 2017. And if you move to the next slide, you can kind of see the different levels of pre-file and post-file and how many youth receive them. Unsuccessful closures decreased by 94% from 2018 to 2021. And I want to explain that a little bit. When we first started the IIP process, we were basically, the district attorney's office was offering to every youth who came in on a low-level offense. What we found, though, is that now we're a little more careful about youth who are in placement in the community who are not from Douglas County. We generally do not want to supervise an IIP because they often don't stay in the community. And then that becomes a failure because we can't follow up with that youth. So we've been a little more careful about making sure we're not trying to supervise kids who are not from Douglas County or who don't reside in the community. So that's one of the reasons for the success rate being dramatically better than it was. And we were one of the biggest users of IIP in the state of Kansas in the first few years. And even then our rates were good at that time. You can move on to the next slide, please. This just tells you some more breakdown information on the youth that were offered IIP programs in Douglas County. I don't know if there's anything particularly exciting about that. We can move on to the next slide. The Juvenile Detention Center here in Douglas County serves 13 counties in Northeast Kansas. And so sometimes when we look at numbers, we do track the information for just Douglas County only. As part of the 367 reform effort, youth cannot come to detention unless they complete a detention risk assessment instrument at intake, and they have to be eligible for detention. Now, there are times that you can override that. You can override the score to put them in detention. And generally, most of the time, the overrides are as the result of having like a lethal weapon, like the crime was committed with a gun or there was a gun located as a part of that crime, and we'll usually override in those cases. Let's see, and then I want to also point out in the detention stats, child needed care cases were no longer served after July 1 of 2019. We can move on to the next slide. As you can see, the numbers have dropped pretty dramatically. The total Douglas County admissions is on the far right top slide. And then all county admissions are listed in the slide slightly below it. But it's a steady decrease in the use of detention, which is what we would have anticipated, and we hoped we would see from the statistics that we have. And moving on to the next slide. This is just Douglas County admissions and Douglas County days. And when we talk of average length of stay, those things can be affected by just one youth. And so you have to kind of keep that into account. I think we look at average length of stay, and we really probably need to look at mean instead of the way we currently look at it. We can move on to the next slide. And the demographics are primarily what you would expect, which is we mostly serve male youth more than female youth. The one thing we had hoped we would see a decline in was the use of detention for Black and brown youth. And that is still continuing to be a problem. I think the dilemma for us is that we serve such a small population that sometimes it's not statistically significant when you have those small numbers to say that you in fact have a problem. We usually have a core group of youth in the community who use detention, and they come in back and forth, and they come in and out of the detention center frequently. So sometimes you'll see the same youth 2 or 3 times in a year. So that kind of skews that number as well, because they're going to be counted each time they're admitted. We can move on to the next slide. As you can see, the use of detention is decreased. Average length of stay, again, like I said, can be skewed by one person when you're talking about small numbers of youth. But you can see the average age population has decreased by 66% from 2015 to 2021. So we're seeing the decreases we anticipated. I do want to point out that detention center staff not only supervise the youth in detention, but they also monitor everyone that's on house arrest in the evening and weekends. They also provide all the UA drug drops for the drug court. And they also provide coverage for intake and assessment and do intake and assessments on evenings and weekends. So they're doing a lot of things besides just juvenile detention work. And we can move to the next slide. The next thing is called conditions of release supervision, which is essentially PreTrial. It's basically for youth who've been incarcerated in a detention center, and the court can make a determination they want to release them on conditions of release supervision. The conditions of that release is approved by the court. And I want to point out that a youth can still receive an IIP or a diversion even after they're on conditions of release. The other thing I want to point out is that when we supervise a youth at conditions of release, at the time, if they are going to be sentenced for an offense, we will take all that information to account when we do the pre-sentence investigation for the court. The court would have order a pre-sentence investigation, and we would also report on their compliance, the length of time they've been serving on conditions of release. And there are a number of times that we've actually recommended closure because the youth has already met all the expectations we would have if they were on probation. So we basically want to ensure that we're not over supervising low risk youth, and the supervision levels are determined by risk. And that's a tool that we use called the Youth Level Service Case Management Inventory. All youth who are going to be, that are adjudicated, receive that risk assessment tool, and then we, the decisions in terms of what needs to happen to them on probation are as a result of that risk tool. You can move to the next slide. This is the number of youth that we've supervised in conditions of release or pretrial for Douglas County. And even as you'll see, new participation on the conditions of release, that is dropping as well, which you would anticipate, because low-level offenders are generally, low-level offenses are generally offered an IIP or a pretrial, or I'm sorry, or diversion. So we would anticipate that those numbers would drop. And we can move to the next slide. You can see the total days on supervision, and that's for everyone. So that varies pretty dramatically, but that's why we take all that into account when we do a pre-sentence investigation, because oftentimes kids have served the entire time they would have been in probation already on conditions. We can move to the next slide, please. This is just a demographic background of youth that are on conditions of release. And we can move to the next slide. Electronic monitoring was started in 2018. It's considered an alternative to incarceration. The judge can release a youth from detention on house arrest or electronic monitoring. This option provides a higher level of supervision and accountability for youth. Generally, youth are released on electronic monitoring is typically used in cases where there is a victim that the person is not to have contact with, or a location that the youth is not to return to. And those are the two primary reasons for putting a person on electronic monitoring of any kind. Usually, in most cases, I can't think of any that don't, the youth that are on electronic monitoring are also on conditions of release and have supervision requirements related to that. We can go to the next slide. And this gives you an idea of the youth that we've supervised since 2018 on electronic monitoring, and which of those. So we have conditions of release youth, ISP youth, we have youth on house arrest only. Generally, that's traffic related. And then we'll have youth who are on conditional release from a juvenile correctional facility, which is a state institution. We've had, I think, one youth that's been released on electronic monitoring from a JCF. And you can move on. And then I just listed some future topics that you all might want to consider having a conversation about child in need of care. What we call crossover youth, which is a youth that may have offenses, but is still being monitored in the child in need of care side of the world. We also have a lot of truancy and day school numbers that we want to talk about at some point. Juvenile probation, both court services and community corrections, and then inpatient psychiatric care for youth. And we're open to questions. Suzanne, you have a question?
Actually, just more comment. Thank you, Pam, for the presentation. I just wanted to add that we are working with Building Peace to get our restorative justice program launched, and we're going to be working primarily, start that program with our juvenile offender population. So I just thought I'd throw that in. And then the other point I wanted to make is that we're seeing increase across the country in youth gun violence, some more serious crimes being committed by youth with firearms. And our office has a strict policy on firearms types of offenses. So we're going to see how this is playing out. And I think that I wanted to just kind of raise that with this group, a very high concern for that we're seeing across the country. So those 2 points I just wanted to throw out there.
And just as a matter of information, we set aside some money in our reinvestment grant for 2023 to help pay for building peace services with youth.
The only thing I'd add is that last slide with future topics, you know, we were really hoping to get some feedback from the CJCC of these are areas that you'd like to hear more about related to juveniles. You know, Pam and Judge Klepper and I could probably talk forever and ever and ever about all these things. So, but if it's not of interest to the council, we can, you know, I think we're also looking for some feedback on areas where you'd like to have more information.
Lori?
This is Lori Alvarado, CEO at DECA, and I will continue to probably talk about the prevention work that we could enhance in the county if we were thinking about alternatives funding sources to explore funding sources. I think the more that we can prevent connection to the criminal justice service and system with our youth, I think that's better for everybody. So I'm going to continue to say, as I've said multiple times, if we could think about how to focus on prevention to help alleviate even contact with the system, I think that it needs to be part of the discussion in the continuum.
Thank you. Well, if we don't have any other thoughts, I want to thank Judge Klepper and Lee for being available today to answer any questions that you have.
Yeah, I don't know, just I hate to sort of let this end without giving Judge Klepper an opportunity to sort of provide some comments about kind of where you think we are. And so maybe Judge, yeah, go ahead.
Sure. Yeah, I can. I mean, you know, I think Douglas County, generally speaking, does an excellent job of providing tools in the toolbox. And you know, the district attorney brings up the Building Peace Initiative. That's another good example. And, you know, I certainly agree with Ms. Alvarado that the more off ramps, the better for juveniles. You know, when I first started doing this work years ago, somebody told me that the chief goal of the juvenile offender system is to avoid the adult offender system. That's the real reason it's a thing, is to keep people out of grown-up criminal stuff. So I think, you know, we all know that there's no one type of kid. They're a whole spectrum. And so not everything works for every kid. In fact, a lot of things don't work for lots of kids. So the more options we have, the more off ramps on that road, the better. And every single option, every single tool in the toolbox, I think is something that I know I appreciate. And I will say, the folks at Youth Services, DCYS, do a great job in my experience. They're extremely reasonable. I think they do a very good job of seeing not just a kid, but also the family, and taking a more holistic view. It's not a cookie cutter evaluation that I get on a pre-sentence investigation. It is absolutely kid specific. It's absolutely tailored, but it's also, you know, in my experience, inscrutably, I don't want to say legal, but it conforms to the statute in a way that is very refreshing to me, and it's very helpful, because then I can go through it and say, okay, here's where this statute applied, here's where this statute applies, et cetera. And so it all makes sense to me. And I give Pam's staff a lot of credit for that. I think they do an excellent job of working with a kid and with a family, and acknowledging that this is not, that this is frankly a very complicated area of the law, because we're dealing obviously with children. And I'm also the very first person to say that I don't believe, generally speaking, that juvenile offenders wake up one day and decide to go commit a bunch of crimes. The children who find themselves in the juvenile offender system, generally speaking, and there are obviously exceptions, generally speaking, make 3 or 4 dumb decisions in a row, often because they're not being very well supervised, often because they're with some friends who are not great influences. But it's the things you think about. It's the same influences that you imagine that cause juvenile offender crime. And, I do think on the one hand that people might be surprised at some of the, I think some of the alleged crime in Douglas County that is committed by people under the age of 18 would surprise some people. I think some of it is very serious in a way that people might not expect. I think the average person thinks that juvenile offender stuff is a little bit of theft, a little bit of battery, that's about it. And to be fair, that is a lot of it. There's no question that's true. But there's also very serious high-level person felonies out there that are committed in this community that will absolutely curl your hair. And I think it is important for us in the community who are in positions of some influence to acknowledge that, as I say, it's a spectrum, that kids come in all shapes and sizes, and they interact with the system in fundamentally different ways. And I think it's on us to provide them with every possible option to get out of this. Within some reason. I will tell you my approach, generally speaking, is to try to give every kid the benefit of the doubt as much as I possibly can. I know that can be frustrating to some people at times, but I just generally think that the overwhelming definition of a kid as opposed to an adult is that their future is not yet written. And I think we owe it to them to do the very best we can to make sure that what was hopefully a youthful mistake is not a life-defining moment. As folks have indicated, I could talk about this all day long. Crossover youth and the interaction with the child native care system is a huge issue in Douglas County. As I think some people are aware, there are a lot of children in Douglas County who are from other counties who are placed here in foster care in various ways. And I don't think this is a controversial thing to say, but children who are subject to DCF custody or foster care tend to be involved in the juvenile offender system. And candidly, children who are involved in the juvenile offender system tend, it's not a one-to-one correlation by any means, to be more involved in the child welfare system. And that's not fair. Obviously, it's not fair, but it's the facts. I've often pointed out that I think a big defining feature of children who are involved in the child welfare system and why they seem to commit so many juvenile offender crimes is just that they're supervised. I mean, if a 15-year-old kid in your house pushed your 14-year-old kid, you probably wouldn't call the police. But if that kid did it in a group home or in a foster home, a lot of those people are trained to call the police. And I don't even necessarily blame them for doing it. But the point is simply that now we've got a witness. Now we've got an officer's report, and away we go. The point being, the exact same thing could have happened in any one of a number of homes in Lawrence or anywhere in Douglas County, and nobody would have thought anything about it. But because that kid is a child in need of care, they're monitored, they're watched, they have witnesses watching all the time. And then that kid who already was at a disadvantage now has an additional disadvantage. I don't know what the solution to that is. I think the IIP is a great thing. I think the legislature's goal, or at least what I perceive to be their goal in Senate Bill 367, is noble. And I think the data that we have here bears that out, that it's been successful in Douglas County. And I candidly am proud of that. I think that's good. I think a lot of that data is very, I think it's remarkable. But as I say, I can talk all day. I'll shut up though, because I don't think you want me to.
Lori, for the members of the public, they can't read the chat. So if you want to share your comment there, that might be helpful.
I just was responding to a judge's comment about foster homes. He is correct. Foster homes are required by state regulation to report certain offenses to the police that occur in their homes. It's just part of the state regulation. So he's right. Sometimes children in need of care get reported more often because it's state regulation.
Well, and I'll add to that too. If anybody's familiar, Dr. Nadine Burke-Harris wrote a book called The Deepest Well. That's sort of common in my circles, where she talks about adverse childhood experiences, or your ACEs score. And it's a fascinating and terrifying subject because you learn about it and you learn how childhood experiences, often before a kid knows anything, you know, when you're an infant, 6 months old, stuff like that, how things that happen to you and to your family can cause impacts upon your actual biology that can change who you are as an adult. And as I say, you learn that stuff and it just gets you where you live, at least for me. I bring it up because if somebody's wondering, what can we do for the juvenile offenders of Douglas County? Or frankly, more accurately, what can we do for the children of Douglas County such that they don't become juvenile offenders? I mean, candidly, I think the answer is a lot of upstream stuff. I think we support families. I think schools need more funding. I think we need jobs with good benefits, and we need, you know, better drug treatment options and mental health treatment options and things that provide supports to families such that those families are not, frankly, in a position where they can't supervise that kid or teach that kid to make good decisions. And another one of my truisms is that no one literally ever has been born knowing how to make a good decision. Children must be taught to make good decisions. It's not something that you just wake up one day and you can do it. And if a kid is never taught how to make a good decision, frankly, they won't. And we will hear about it.
Bob,
Yeah, I just wanted to build on what the judge just said, because I think the work that's been done in prevention, or that's being done, or is kind of in its early stages. When we look at the data in Douglas County, there are several points of, you know, reasons for concern if we're going to have programs and initiatives that are going to introduce hope. So if you look at the KCTC data that we've been analyzing with Engage Douglas County over the last 3 years, all of the risk and protective factors between the ages of, you know, between 6th grade and 8th grade have declined, or risk factors have increased and the protective factors have declined. Suicide visits to the emergency department have increased. Not to say everybody should be scared and feeling hopeless, but the data in Douglas County tells a story related to youth. And, you know, until we really start digging into that data and asking ourselves what we can do in this prevention space, you know, the longer that this situation is just going to drift, and as it drifts, the numbers get worse. So, you know, I just wanted to throw that out. And, you know, I throw that out from this perspective of somebody who I have an ACEs score of 8. So there are ways to build the protective factors in a community that can help a person to thrive. And those things are significant adults who are not their parents. Those things are after-school programming that engages young people, helps them to discover their passion and their spark, and then connects them with significant adults so they can find opportunities to build on that. This is not, you know, this is not rocket science, but we actually have to start doing some proactive, intentional work if we want to impact those numbers. Because if we don't impact those numbers, then the things we've been trying to work and build on in the crisis services space, the need for that only grows greater. So, you know, I'd really encourage everybody on this call to start looking at what Engage Douglas County and the health department are elevating in terms of what the data is saying, because our community needs some real intentional focus on what's happening with young people. And again, from a perspective of recognizing points of concern in the data so that we can match them with programming, initiatives, and interventions that give people a reason for hope. Because parents in this community, if you talk to them, are at wit's end. It's, you know, whether they're in the criminal justice system, whether their kids in the criminal justice system or not. And the struggles as a result of COVID are real, true, and significant for the long-term health of this community.
I appreciate you saying that, Bob, and I think you're right. And I think I totally, you know, and maybe this is something we could have, you know, a sort of blend over from conversations that are happening with Engage Douglas County and the CJCC, so this group could get a sense of what's happening in that sphere. But and in addition to that, just, you know, I think one of the things that, and we've shared this with Lori in the past, like prevention programs, you know, this is a long-term investment, and we're not exactly sure always where the benefit will be. So I think folks, it would help for this group of folks to see what best practices are for what's happening upstream. And maybe we need to be doing some more work in that space. And it's not just after school, it's not just after school programs, folks. And it's a lot more about us as adults and what kind of mentoring are we showing to the young people in our community. So, Lori, would that be something your team would be interested in doing with CJCC?
Yes, this is Lori Alvarado at DECA. Absolutely, you would be in a place where you would have to put them on a time limit and shut them up because they have a lot to say. We have teenagers that are engaged in that work and being involved in peer-led initiatives, which is also a best practice in some of the prevention work that we do. We've done some culling, I guess, of programs and strategies and initiatives that we think would be best suited to the data that we see in Douglas County. So we would be happy to share what has been done, share how we've taken the data and matched appropriate interventions and activities to that data, and also what could be in the future if we decided that was something we wanted to do. And I'm seeing in the chat from Jill about Resiliency Coalition and the Child Abuse Prevention Task Force, and those two entities are also connected to Engage Douglas County. So we certainly could bring that whole picture together. So I think that's something that would be helpful as we think about a comprehensive prevention approach. And yes, you're right, Sarah, it does involve adults and our attitudes toward that, the things that affect teenagers and youth and preschoolers. To judge's comment, it happens from the beginning of life. So the trajectory can be set early in someone's life, and we can address those issues very comprehensively in this county if we choose to do that. So yes, short answer, yes, we would love an opportunity to share what's going on and what we could be doing.
Well, we can add that to a future agenda. Sounds great. Thank you, everybody, for your input. And again, thank Judge Klepper and Lee for being available to answer questions and provide comment. Very helpful.
Let me respond to you, Pam, and say candidly, and I have to go momentarily to jump on another meeting because that's just how I live. But what I'll say is candidly, this conversation and conversations like it are emblematic of our community. I think the juvenile court, my job, this whole situation is because the people of Douglas County care about juvenile justice and care about the role of children in the legal system. And that's evident by virtue of all these programs, all this effort, which obviously all of it needs to be improved upon. I'm the first one to say that too. But I think the fact that the conversation happens in the first place is a telling and good sign. So thank you for having me. It's a short answer.
Thank you.
Thank you. I'm out of here. Have a good day.
Our next agenda item is a presentation on pretrial release program evaluation and update from Dr. Cravens and myself. The CJCC Alternative Program Evaluation Committee does an evaluation of each of the alternative programs annually. The first task that the committee does is putting together a packet for self-evaluation. And so each time the stakeholder group changes slightly depending on the person's interest in the subject matter that we're currently looking at. So there was a behavioral health team that looked at their evaluation stuff, and then the pretrial was a slightly different group. But what the committee usually does is they create a packet of information. One is the introduction and history of pretrial, a logic map of pretrial, program goals for the program in question, best practice references related to the program that we're evaluating, a procedure manual that aligns the procedures for that program, which in this case is pretrial, an explanation of the various programs and processes for that program, and then any related forms. And we generally have people who contact us fairly frequently asking us for information about our program. And so we give them the evaluation packet so they can see exactly how we got started and how we're doing what we're doing. And so as a part of that evaluation, we look at our data to get an idea of our story in terms of how it's going. And so I'm going to let Dr. Cravens present the data.
Hello, everyone. I hope you can see this.
We got it, Matt. Thanks.
Great. So today we are going to be discussing Douglas County's pretrial release program, as Pam said. So let me just start with a little background so we're all on the same page. The pretrial release program is an alternative to incarceration program that was established in 2017 and actually got going a little bit in late 2016 too. The goal is to reduce incarceration rates due to individuals' inability to pay bond. It's available for people with district court cases and not municipal court cases. So the total number of pretrial release supervisions since the start of the program in 2017 is 1,755. So the program has actually kept a lot of people out of jail pretrial since its inception. Just note that some of these supervisions are for the same person. So there are less than 1,755 unique people who have gone through the program. But on any given day, the current population under pretrial supervision is about 200. The population on April 1st of this year was 2,205. Here's a flow chart of the pretrial release program. And I think this will give you a little bit better sense of how it works and what it does. So after a person is booked into jail, he or she is deemed eligible or ineligible for the program based on whether or not they have holds from other counties, previous pretrial supervision violations, or other detainers. And if they're ineligible for the pretrial release program, they have a partial report completed. You can see that in that second bottom box there. The report doesn't contain any pretrial supervision recommendations, and the person is not released from jail as part of the program. So this is sort of the normal course of events here. The judge then sets bond, and the person either pays bond and gets released or remains in jail. So we recently enacted a look-back eligibility process. That just happened a little while ago. So what that does is it occurs about 1 to 2 weeks after the partial report is completed. This is to determine if holds and detainers have been dropped and whether a person is now eligible for the program. This gives people sort of an extra chance at pretrial release. Pam knows a little bit more about this. Pam, do you have any sort of comments, anything I'm missing about the look back period?
I also want to point out, we do the look back, our staff do the look back, but we also have judges from the district court who frequently communicate with us throughout the week on cases that come to before them that they want us to re-review for pretrial release. So there are a number of ways we do kind of look back. Sometimes it's the judges that start that, and sometimes it's just something we do based on the caseload of people we looked at the previous week or two.
So then we see here in the second box on the top is the eligible group. So if the person is eligible for the pretrial release program, they have a complete report filled out for them. In this complete report, individuals' risk score is listed, which contains the risk of reoffending and the likelihood of returning to court. It also lists a pretrial monitoring recommendation based on the risk score and the current offenses. The judge then decides whether the pretrial supervision is granted or denied, and what level of supervision is required. And this may or may not require electronic monitoring depending on the level of supervision. If pretrial supervision is denied, the judge then sets bond and they may or may not remain in jail. Just so everyone knows, electronic monitoring and other supervision provided through Douglas County pretrial release program are at no cost to the defendant. Any questions on the flow chart? So this slide just summarizes what I said about complete and partial reports. I'll let people sort of read that. the bottom bullet mentions that these reports are submitted to the judge and district attorney. In misdemeanor cases, the reports are also sent to defense counsel, which is typically Kansas Holistic Defenders now. All right, so what this figure shows is that complete pretrial reports are being submitted for just under 60% of in-person first appearances or in custody first appearances. So this percentage should rise soon based on a recent change that I'll explain here on the next slide. But what we're seeing generally is a positive trend of growth in the percentage of people eligible for the pretrial release program. Hopefully this trend continues. We do want as many people to be eligible as possible. So here are the reasons why partial pretrial reports are submitted. So in other words, the reasons why people are ineligible. The most common reasons are having a probation violation, an out-of-state hold, a pretrial program violation, and an out-of-county hold. Pretrial program violations can include people with repeated prior attempts at pretrial supervision who failed to appear in court or violated the conditions of supervision, or someone who tampered with a GPS bracelet, or someone who violates an exclusion zone order while on pretrial release, or with a domestic violence case. So one important, or a couple important notes is that beginning in 2020, the judge requested that complete pretrial reports be submitted for people with municipal court holds and FTAs. So these are listed as reasons for denial or for non-eligibility, but that's no longer a reason. And then beginning in mid-March 2020, so just last month, complete reports are now being submitted for people with Douglas County probation violations. We haven't evaluated this change yet in the data because it just happened, but it is likely to make a lot more people eligible for pretrial release. Pam, is there anything I'm missing about the probation violation change?
No, I think you've got it.
So here's a little bit more detailed figure showing the release or the reasons why pretrial reports were submitted, or the reasons why partial reports were submitted and why people are ineligible. Note that municipal court warrants and FTAs are excluded from the figures. We wanted to show the data across years in a comparable way. And as stated here in the second note, municipal warrants and FTAs were frequently listed as reasons only in 2019. One note here, the decrease in Douglas County holds in 2020 may have been due to COVID, reducing the number of arrests and warrants being served in the county. So this is the percent of pretrial reports where pretrial supervision was granted. It was a little over 80% in each year. This indicates a pretty high degree of agreement between the judge and the pretrial reports. This figure shows that an astonishingly small percentage of people in jail at first appearance had a defense attorney present from 2019 to 2021. In fact, only 15 first appearances had a defense attorney present. A large change was made on February 1st of this year when Kansas Holistic Defenders began representation at first appearances for individuals with misdemeanor cases. So individuals with felony cases are still not assigned counsel at first appearances, but the misdemeanor people have changed. This figure shows that the DA opposed or requested modification for 16 and 11% of defendants after a complete report was submitted in 2019 and 2020, respectively. The DA's office has begun to oppose or request modification more in 2021 under the new administration. Let's see, 29% or 126 times in 2021 was the number of opposing or requesting modifications. So this table shows the reasons that the DA opposed pretrial release or recommended changes. It shows 2019 to 2021 data. CS stands for cash or surety. With a cash or surety bond, the defendant can either pay cash or pay a bondsman about 10% of the amount to secure release. So in 2021, the DA opposed pretrial or recommended cash or surety bonds only, or requested pretrial with a cash or surety bond more often. 27 of the 34 instances of the DA requesting pretrial with cash or surety bond were in 2021. In 2019, the DA sometimes requested sober link, sweat patch, or drug testing, but in 2021, the DA did not request those options at all. So this shows that about half the time the judge agrees with the DA when the DA opposes pretrial release or recommends modifications. From the table, we see that there were 129 times when the DA opposed pretrial or recommended a cash or surety bond only, and the judge agreed in 69 of those instances, or 53% of them. Overall, in 2021, the judge approval rate for the DA recommendations declined somewhat to 42% from 57% in 2019 to 2020. The judge approval rate declined significantly to 26% when the DA requests pretrial with CS bond. So just note that imposing a CS bond largely makes pretrial moot, just because the person can't be released unless they post bond. Sometimes the judge modifies the pretrial request in ways other than how the DA requests. Those instances are not counted as judge approvals in this slide. So here's some demographics. This shows the gender distribution in 2021 of first appearances, in custody first appearances, and people granted pretrial release. That shows that women's chances of being granted pretrial first appearance are higher than men's. Women's chances are 56% and men's are 45%. Women make up a somewhat larger share of people granted pretrial release than in custody first appearances. This figure here is generally positive news for the program. People granted pretrial release are not disproportionately Black, Native American, or Hispanic when compared to the in custody first appearance population. So we do see significant racial disparities in the criminal justice system in a lot of different areas, but this area does not appear to be a program with a whole lot of disparity, which is good. We see similar racial distributions between the first appearance population and the people granted pretrial release, and a similar Hispanic ethnicity percentage as well. Any questions here? So here is what we call the praxis. This is how pretrial officers determine the level of supervision they recommend to the judge. The risk category shown on the left side is determined by a risk assessment, which I'll display in future slides. The type of offense is shown in the top row. Risk and offense type together determine which supervision type is recommended. So max and enhanced max are the most serious supervision types, and they require GPS monitoring. Intensive no longer requires a person to be on GPS, and removing GPS from intensive doesn't appear to be having an adverse effect, as we'll see in upcoming slides too. So people in all supervision levels receive court date reminders, monitoring for new offenses, and check-ins after court hearings.
And I will say that we've made adjustments to the praxis over the time period of pretrial. I believe this is version 19. So there have been adjustments throughout the process as we have data.
So this is just a summary of what the program requires of defendants at each supervision level. I'll let people read this. This is the risk assessment instrument used to determine if someone is low, moderate, or high risk. So officers answer each question about the defendant and add up all the responses to get a single score. The overall score determines if they're low, medium, or high risk. As you can see, there are questions about whether the person has a local address and has lived in the area for at least 12 months, or if the person is currently on probation, parole, or community supervision, or if they've had prior FTA arrests. And this is the distribution of participants by monitoring category. So we see here that intensive monitoring is the most common category. 42% of participants had intensive monitoring in 2021. The categories from least to most serious are administrative, enhanced, intensive, max, and enhanced max. And as mentioned in the previous slide, max and enhanced max require GPS. So this table shows whether pretrial release participants had a misdemeanor or felony as their most serious offense. About half of pretrial participants in 2021 had a misdemeanor case and about half had a felony case. I think some people sort of react to this table by asking why are there so many people in jail with misdemeanors who would be released through the pretrial program. You know, that conversation would probably take longer, maybe for another time or Q&A, but I suspect that some of the reasons are that there are people booked into jail with a DV or domestic violence cases who are automatically assigned bond, and domestic violence is often a misdemeanor. And there are many other types of misdemeanors that the court automatically sets bond for, including some DUIs, and there are people with failure to appear for misdemeanor hearings in municipal court. I don't think there's sort of one reason, but we can delve into this data in the future if people are curious too. So the average time on pretrial supervision rose quite significantly between 2018 and 2021. It rose 64% for successful participants and 103% for unsuccessful participants. I believe that the major reason for this large increase is COVID. So COVID really did increase case processing times. There was also a new DA in 2021, which may have contributed to the longer case processing times too. But this is a pretty significant increase we're seeing here. Any questions? %44% of pretrial participants were supervised with electronic monitoring. 71% of felony participants and 14% of misdemeanor participants were supervised with electronic monitoring. And this percentage is going down in the last year or two, as we see intensive no longer requires GPS or electronic monitoring. And this is looking at the outcome. So this is what a lot of people are more interested in. What we see here is that about 2/3 of pretrial participants successfully completed pretrial supervision. 1/4 were unsuccessful due to a failure to appear. 3% were unsuccessful due to a new charge, and 6% were unsuccessful due to a failure to comply. It's worth emphasizing that the percentage with new charges is very low. It's about 3%. So this bodes well for public safety aspects of the program. With regard to FTAs, pretrial officers are now calling people in the program and reminding them about upcoming court hearings. So we already do an automatic calling system in district court. Municipal court has an automatic calling system as well, and they do text reminders as well. But this is sort of an additional step. So pretrial officers are now calling when they don't have too busy of caseloads. When they have time, they're calling people with a more personalized call to remind them of their upcoming court appearances. So this step should hopefully increase or reduce the FTA rates for people on pretrial supervision. Anything I'm missing, Pam, about the new sort of calling system?
No, I think that covers it. I was going to say that sometimes when you see failure to appear as the main reason for detention, you need to understand that there's no new charge related to the failure to appear. And it doesn't tell you the underlying offense for why they had a failure, what they failed to appear for. And sometimes that's what drives the decision in terms of getting out or not getting out, is the underlying offense.
All right, so this generally shows that the success metrics have improved in the last few years. The percentage of participants who successfully completed pretrial supervision rose 6 percentage points from 2018 to 2021. The percentage who were unsuccessful with failures to comply and new charges declined. The unsuccessful failure to appear rate did increase. So FTAs have become a larger problem. Hopefully 2021 data is just an anomaly. It doesn't necessarily seem to be, but as I mentioned, officers are working actively now on improving FTAs. That's one of their sort of set goals for this year. Shay.
Sorry, I was going to ask if the, I know we said we're on version 19 of the praxis, Pam, but if the court is determining, and it looks like half the time period to modify it, is it time to review that again? Or are there different reasons that we still think the praxis is okay? There are just other reasons the court's not following it, and or the DA's office isn't comfortable with it.
That's probably a conversation we need to have, Shay. I mean, we do review it. We did reach out to stakeholders as part of this committee, and also a prior review, because we've reduced things like cash, and we don't ask for cash any longer. Like he said, like Matt mentioned, we don't have house arrest for as a requirement for certain levels. So we're trying to reduce the level of supervision for lower risk participants. Suzanne.
So Pam and I have talked a little bit about the decline in our concurrence rate in terms of recommendations for a cash or surety bond on first appearances on some very serious cases. So this is an opportunity, I think, for now that we have this data, to kind of take a deep dive, at least on our part, to try to figure some of this out. I will tell you that, you know, with public safety being our primary concern, the praxis does show, we did disagree with this when we were doing our kind of, Pam is inclusive. We all came together. She talked about the stakeholders being at the table and talking about the revision to the latest revision to the praxis. But if you look at that particular screen, it shows level off-grid felonies, which are very serious. They're essentially off the grid, which means you could serve a lifetime in prison for these violent crimes. Yeah, thank you, Matt, for putting that up. So the dark blue there, off-grid felonies are Jessica's Law cases. Level 1, 2, and 2s are usually first-degree murder, very violent person felony crimes. And if you look at the enhanced max blue column there, it basically says that these individuals can be out of jail in the community under enhanced supervision. We take a different view on that, just again, with firearm violence that we've seen and public safety concerns related to just the use of firearms in ways that are very, very, very dangerous to our community. That's the, I think for us, I can say without really doing a deeper dive, a point of contention that we take a firm position on in terms of asking for a cash or surety bond. So anyway, we're going to take a look at that. This is very helpful. And I do again realize and appreciate our concurrence rate has gone down some. So we just need to figure out why, and if there's a way that we can fix it. I don't know. The other thing I would point out is that the failure to appear, the numbers on that and the misdemeanor numbers, that's not coming from our office. The only reason I'm bringing that up again is I kind of feel like a broken record. We're not responsible for those individuals who remain in jail. We're not filing any cases on failures to appear. And that's certainly not a DA, our office, and we're not involved in that. On the misdemeanor piece of it, we do have DV individuals in jail. We recommend, just because of the lethality that can happen with a especially serious domestic violence situation. So we would rather have that individual sort of the cooling off period, you know, that take place again for public safety and the safety of the individual who's potentially harmed. So those recommendations are made on some of those perspectives. I think at the end of the day, you know, we need to come up with the new potential bond schedule. I know, and I'm speaking for law enforcement here, and I don't want to do that. I'm just kind of speaking, want to say that my position is that we've got a presumptive bond schedule that may be outdated. We've tried figuring it out. We've asked the court to participate in that, and that wasn't something that they wanted to be involved in. So the courts ultimately set the bond or no bond or pretrial release recommendations. So I think there's more to be looked at least from our office and where we're coming from. And certainly we want to make sure that we have as many people back in their homes, in the community, keeping their jobs. Those who are not serious public safety concerns, we are absolutely supportive of the pretrial release program, which is very robust and just a really special program that is that comes with our great community in Douglas County. For violent offenders, those who are alleged to commit offenses with firearms, with violent crimes against individuals, we take a different position on that. We just do, for reasons that I think we need to start really thinking about and looking at, and what those situations and those kinds of cases do what they involve. Like I indicated earlier, I have a very firm position on any sort of, you know, incident that involves a firearm. And we all know that if you've got a gun with you and you're drinking and you get pulled over and you pull out the gun, all it takes is someone pulling the trigger. So we've come up with a fairly zero tolerance policy for gun violence. I really stand firm on that at this point, but I think that position may inform some of what we're seeing in these numbers. I don't know. So what I would like to do is be able to work with Dr. Cravens and looking at our data, seeing what kinds of decisions are being made in terms of the pretrial release program for purposes of, you know, the recommendations that we're making, or sort of we have differences of opinion on with regard to what pretrial services recommends, and then report back to the CJCC. So I appreciate all of that's been shared with us today, and it really does, you know, pique a lot of curiosity on why our concurrence rate has gone down a bit. But I think we need to figure out what those reasons are and understand, and certainly understand them. And then if there's any ways we can make further adjustments, we can do that.
And I'm happy to work with you, DAVL does, on digging into the data more. I think that's always a good step, and we can follow up on that. One quick question. Does anyone know when the bond schedule was last modified? You mentioned that it may need being updated, and I've heard that it hasn't been updated in quite a while. I was just gonna get that clarification for the record.
Yeah, so it's interesting you asked that question. There's nothing in digital form that we can find in our office. In fact, I literally have a copy of a copy of a copy of a copy, so that we hand out to all of our staff when they do first appearances. It's fairly outdated, and we've heard different, you know, different answers to that question. All I know is that it's time to be, I think, looked at, and I think we would all welcome that, so that we kind of understand at least clearly what our position is on some of kind of the reasons that we're asking for a cash surety bond, and then the public understands what those are. So I think this is something that needs to be reviewed, and we wanted to do it. Again, I don't think the courts wanted to be involved in that. We've asked about that. So I don't know if we create our own, and just so that my position at this point is to let the public know what kinds of cases we will be very firm on in terms of asking for a cash surety bond, and why those reasons exist. And typically they're grounded in public safety concerns, like I just talked about. And then other than that, I think we want to defer to pretrial services. So the question is then figuring that out. So again, that's a long-winded answer to your question.
Commissioner Littlejohn.
Yeah, thanks. And this question was just for District Attorney Valdez. I just wanted a little bit of clarification on the FTAs. You said it, and I thought I heard that it wasn't on the municipal side. So I'm sorry, the district side. So it's on the municipal side. Is that what we're thinking?
Well, yeah. So the failure to appear, I think Dr. Cravens pointed out that slide. I want to make sure people understand where the failure, those that are kept or put in the jail and held in the jail on failures to appear are not coming from our office. We're not filing those charges. Those are orders. Usually someone doesn't show up to court, and the court will issue a warrant on a failure to appear for a proceeding, as Pam described. And so they're booked on that. But that's from a court's failure to appear. It's not our office.
Yeah, Commissioner, I don't believe it means it's municipal. I think it means it's from the court.
Right.
Municipal
Okay,
court
cool.
is, yeah.
I just wanted a little bit of clarification on that.
Shay, thank you. Shay.
Sorry, I want to make sure I'm understanding, because I think part of if I'm recalling exactly how this went, the reason we had the praxis is so that the issue of not having an attorney at first appearances would be sort of minimized in terms of the consequence for that individual. But if we're having, I guess my point was, if we are now seeing that over a quarter of the time, so 1 out of every 4 times there's an objection, and then half of those are being modified, I think that's a bigger problem than I expected. I think the slides to show. Obviously, the great thing about having holistic defenders right now is that can't happen on the misdemeanor side, at least without that person being represented. But if, for instance, maybe the praxis doesn't need to address off-grids or level 1 and 2, if that's what's driving up the numbers, but I don't know how many level 1, 2 and off-grids we have filed here, so I don't want to dive into that. But if that's not the bulk of the issue, I think we're creating a bigger issue for ourselves. So my question was really not necessarily about the bond schedule. I think those are competing views about whether or not we need to modify the cash bond or to move away from a cash bond at all, which is what I thought the goal was intended to be. But whether or not that it's time to see if there is not an agreement as to the praxis, then I think that is a problem that warrants a lot more feedback. Otherwise, we need to come up with different solutions. If the whole point was to avoid having individualized discussions on every case, you know, for bond issues, I think that at least was my understanding of the point for the recommendation that we have the praxis as part of this. If I'm misunderstanding that, then that's fine. Or if we just need to review it again or something, I guess that's what I'm asking is how can that be more helpful? Because right now, I just want to make sure that we're not setting ourselves up for bigger problems.
So Shay, I'll just respond. I mean, when we did our last meeting on the praxis meeting, we did voice concerns about that blue, you know, the off grids and the level 1s and 2s as being part of even that part of pretrial release. I mean, I think that was to your point. I think we agree. That was a discussion. If you take out, and I don't know what the answer is, I guess that's what I'm saying. Why is it that our concurrence rate is down? And I think we need to figure that out. If it is the you know, the off grids and levels 1 and 2, well, those are that, and when you're in that space, I mean, that's public safety really matters. I mean, we've got to make sure that we are, maybe we have a discussion, it's a discussion for another day, but what I recall from the last time we looked at the praxis, we had serious concerns. I don't want to say it was objections, certainly, but because the whole praxis covered every level of crime that's charged, but we did have some concerns about the kinds of crimes that are in that one column, and again, that's because of our public safety concerns. So I think we agree on this, and I think we need time to kind of look at where those where we're not concurring. Is it in that blue column? Because if that's the case, then we know, I think that's something we need to start to discuss.
This is Pam again. I think that we need to do a deeper dive to figure out where we're having a difference of opinion. And then we can decide then if the praxis is an issue, and then we maybe need to have another meeting with the stakeholder group again. But I think we need to first of all figure out what charges are creating the dilemma. Shay, did you have another question or?
I think I just forgot to take my hand down because it's below my screen.
No problem. Darren?
I just, again, as a community rep, I just want to underscore as essentially a layperson, not a stakeholder, community member, Shay's concern is one that I share. So I just feel compelled to say that based on what the presentation, what I'm hearing. And just a side note, Pam, this is to your point just now. Is it possible to, and I guess maybe this is a question directly for Matt, is it possible to get that information from what we have? Is it just a matter of looking at things, or is there new data that's then got to be harvested to find out whether it's the level 1 and level 2?
I believe we can get that in the data, yes. But I will look a little bit more carefully. I'm pretty sure that's recorded in the database.
Okay, cool. That was all I wanted to raise.
Thanks.
All right. Well, for all program evaluations now, what we're doing is carefully looking at breakdowns by race and ethnicity and oftentimes gender to determine if there's any disparities and identifying ways of reducing them. Here are the outcomes for pretrial supervision by race and gender. So Black participants are 6 percentage points less likely to successfully complete pretrial supervision than white participants, and the group has a slightly higher FTA percentage. Female participants have a higher FTA percentage and a lower FTC, failure to comply percentage, than male participants. So we think that by addressing FTAs and making a real concerted effort this year, in part through the new phone calls and our all goals related to this, that that we're going to be able to reduce some disparities by reducing the FTA rate. So another way of doing this too is ensuring the accuracy of phone numbers in the court system database. And this can reduce FTA rates and improve pretrial outcomes for both Black and female participants. So that's something that we've met with the judges about making sure we send folks down to the court clerk's office to make sure that their phone numbers are updated in the database so they can receive those automated phone calls to reduce FTA rates. So hopefully there will be some market improvements in the next year on that. And this figure shows pretrial success by monitoring level. We didn't quite expect this, but one of the monitoring levels, enhanced, has a lower success rate. And we're not exactly sure why this is happening, but we're keeping an eye on the enhanced group a little bit more now. So one note is I did look into whether Black and female participants had higher FTA rates while on pretrial release, in part because they're on enhanced monitoring more often, and that's not the case. I can provide more details later if you'd like, but I did sort of look at the percentage of pretrial participants that were on enhanced monitoring, and it was very similar across racial groups. So that was a good sign. So we still have to look a little bit more into why that enhanced group's not doing quite as well. But that's it for the data, and open to any questions that folks might have. Darren.
Sorry, just because I'm putting together multiple slides. Does the enhanced group have the GPS or not? Or not? They're not GPS. Okay.
No,
Thank you.
they just report by phone.
Report by phone. Okay.
Mhm. If we don't have any other questions, we might open it up for public comment or public questions. Robin, I'm not sure who's monitoring that. Dana?
I don't see any hands up at this time.
Well, if there's no public comment or questions, and do we have anything else for the good of the order today? Seeing none, this meeting is going to be adjourned. Our next meeting of the CJCC is on May 10th. Thank you all for coming today.